Subscribe to our YouTube channel and don't forget to press the bell icon to get all the latest updates.
This case is not about, my lord, saying that there should be or there should not be a universality of uniforms. This case about whether certain people should be exempted from the rigors of a uniform. And in this particular case, not even an exemption, just an additional, my lord, a headscarf of the same color. So, my lord, this entire debate that, my lord, the petitioners before your lordships are wanting to do away with the uniform regime, or that, my lord, the court is called upon to decide the validity of uniforms, my lord, that is not the issue at all. The issue is about exemption and whether that exemption is a reasonable thing to ask. Then, my lord, kindly turn to the importance of discipline, my lord. And it's very beautiful. I'll not trouble your lordship, but whenever lordships have time, lordships can see paragraph 90. Lordships may make a note. 99 is very important, my lord. That's the argument of the schools. Rules are important. Discipline is important. And then, my lord, para 101. And in fact, my lord, paragraph 100, the judge takes great care, my lord, to say nothing in this judgment should be interpreted as encouraging or condoning the breaking of school rules. And then, my lord, para 101. But this case, my lord, page 52, my lord, the Chief Justice got it, my lord?
Yes.
Yes. But this case is not about the constitutionality of school uniforms. It is about granting religious and cultural exemptions to an existing uniform. The admirable purpose that uniform serves do not seem to be undermined by granting religious and cultural exemptions. There is no reason to believe, nor has the school presented any evidence to show, that a learner who is granted an exemption from the provisions of the code will be any less disciplined, or that she will negatively affect the discipline of others. So, my lord, this is, my lord, I am respectfully urging for your lordship's kind consideration. This case, my lord, is not a case about constitutionality of school uniforms. This case, my lord, is that whether, my lord, certain leeway, a certain exemption, a certain, my lord, degree of accommodation can be given to students, my lord, exercising the religious faith, and, my lord, a little modification is what, my lord, students are asking for. Then, my lord, they discuss this test from 101, 102. Yeah. I am therefore not persuaded that refusing Sunali an exemption achieves the intended purpose. Indeed, the evidence shows, I'm grateful for my learned friend, my lord, I missed this. Indeed, the evidence shows that Sunali wore the stud for more than 2 years without any demonstrable effect on school discipline or the standard of education. This is what the Honorable Chief Justice put to me. Have you been wearing this headscarf? And I said, yes, this is my statement in the petition. And till today, my lord, till the issuance of the circular and the GO, people, students were wearing a headscarf. They were, my lords, following the school discipline. Granting exemption will also have the added benefit of inducting learners into a multicultural South Africa where vastly different cultures exist side by side. Very beautifully put, my lord. Then, my lords, the last paragraph which I want to cite is very interesting, 107. And this is the, my lord, parade of horribles argument. Para 107, page 54. The other argument raised by the school, my lord, last paragraph, my lord, of that page 54, my lord. My lord,
Yes.
Yes. The other argument raised by the school took the form of a parade of horribles or slippery slope scenario that the necessary consequence of a judgment in favor of Miss Pillai is that more learners will come to schools with dreadlocks, body piercings, tattoos, and lion cloths. The same argument, my lord, which is being raised today, that look here, if you permit this, tomorrow you have people walking along. I'm sorry, my lord.
Not 6.
Can I read it again, my lord?
Please read 106 fully.
Yes. Asserting that no stud should not be allowed because it is also a fashion symbol fails to understand its religious and cultural significance, and it's disrespectful of those for whom it is an important expression of their religion and culture. I'm grateful, madam. In addition, to uphold the school's reasoning would entail greater protection for religion or cultures whose symbols are well known. Those are, in fact, often the ones least in need of protection. I'm grateful, madam. It would also have the absurd result that if a turban, yarmulke, or a headscarf becomes part of popular fashion, they would no longer be constitutionally protected, while they have constitutional protection as long as they remain fringes on the society. I accept the popularity of the no stud may make it more difficult to determine if a learner is practicing her religion or culture or trying to impress her friends. But once the former is established, as it has been in this case, the mainstream popularity of a religious or cultural practice can never be relevant. Now, this is what I was saying. Not the essence of 25 is the innocent practice of faith, not, my lord, a display of religious identity. And what the quote says that it is not a display of fashion. And then, my lord, para 107 is what I was commending for my lord's kind consideration. The other argument, my lord, Justice Dikshit got it, my lord, para 107. Yes.
Yes.
The other argument raised by the school took the form of a parade of horribles, a slippery slope scenario that the necessary consequence of judgment in favor of Miss Pillai is that more learners will come to school with deadlocks, body piercing, tattoos, and lion claws. This argument has no merit. Firstly, only see this, my lord. This judgment applies only to bona fide religious and cultural practices. It says little about other forms of expression. The possibility of abuse should not affect the rights of those who hold sincere belief. Secondly, if there are other learners who hitherto were afraid to express their religions or cultures and who will now be encouraged to do so, this is something to be celebrated, not feared. So, my lord, what the court says is that somebody has a genuine, my lord, practice of faith. He wants to wear a nama, he wants to wear a rudraksha. My lord, that should be celebrated and not feared. As a general rule, the more learners feel to express their religions and culture in school, the closer we will come to the society envisaged in the Constitution. The display of religion and culture in public is not a parade of horribles, but a pageant of diversity, which will enrich our schools and in turn our country. Thirdly, acceptance of one's practice does not require the school to permit all practices. If accommodating a particular practice would impose an unreasonable burden on the school, it may refuse to permit it. So, my lord, therefore, I respectfully submit, my lord, that considering the principles which have been laid down in this judgment, and, my lord, which has been followed by our Supreme Court, the wearing of a headscarf is such an innocuous practice and which is completely protected by Article 25. Now, my lords, I have finished South Africa, and I'll just run through my lord, a few other jurisdictions.
We just want to remind you that yesterday you said you will only take to 10 minutes.
But since the question had come from your lordships, so, my lord, I will finish today, my lord. I will finish today. I will finish today. I promise that, my lord. I'll finish today.
But, my lord, there are half a dozen more petitioners who are supposed to argue, my lord.
That's okay. I have a right to finish. I'll finish it today.
You can argue till academic year comes to an end.
15 minutes.
No issue.
Yes, my lord.
We are not in a hurry.
Yeah, but you
We are
should
not in a hurry, but you should be in a hurry.
Yes, my lord. I'll be in a hurry, my lord. I have not repeated, my lords. Lordships may cut me down if I repeat any argument. My lord. I have not repeated any single argument. Yes.
Yesterday you wanted only 10 minutes.
My lord, since the questions fell from the honorable court, I thought it was my duty, my lord, to answer it. Lords, I will finish it, my lord. I will finish it today. Lords, just grant me that indulgence. Lords, I'll finish it, my lord. Lordships have been very patient with me. I will finish it, my lord. My lords, the next judgment which I want to cite is from Canada. and I will not cite paragraphs after paragraphs. This was a
How
judgment.
how these judgments are relevant for the issues involved here
It
in
is
the context of the Constitution of India.
correct, my lord. Correct. I bow down, my lord. But since a question had come from your lordships that how this secular practices, my lord.
Oh, yesterday you cited a judgment where a Malaysian court was
Correct, my lord. Correct. My lord.
reported.
Yes.
Therefore, the courts ask you
Yes,
a question whether it is a
yes, sir.
central court,
Lords, I will not
constitution,
trouble your
or
lordships. What I'll do, my lord, what I'll do, I'll give a 1-page or 2-page note having all these judgments of various
yeah,
jurisdictions.
that's why that
That will
would
be
be
better, my
better
lord. I agree.
instead of
But
reading
lordships will
all
make a note. Just make a
judgments
note.
of the other
My
countries.
lord, just make a note. I'll give the citation. I will not cite it. Lordships will just make a note. I will not cite, recite the judgment, my lord. My lord, sir, this is Supreme Court of Canada, 2006, 1 SCR, page 256. And here the issue was, my lord, whether a school student wearing a kirpan to a school infringes the student's freedom of religion. They said it does, and it should be permitted. That is, my lords, 2006, 1 SCR, page 256, Canada, my lord. The next judgment, my lord, which I want to cite is a House of Lords judgment from England. And that is, my lord, 2006, UKHL 15. And my lords, this judgment, lords, I have to fairly say, this judgment prohibited, my lord, and upheld the right of the school to, my lord, say that a student should not be permitted a full dress, what they call a jilbab. And that I wanted to cite as an officer of the court, my lord. I have to cite. But I also have to tell your lordship that this judgment noticed the fact that that school had permitted students from the Muslim faith to have a headscarf. And therefore, they say it was a reasonable allowance being made, but we cannot go to the extent of disturbing the other students by permitting the entire attire to be changed. They permitted headscarf, but not jilbab. That is, my lord, 2006, UKHL, page 15. So these are the three judgments, my lord, which I wanted to cite from, my lord, common law jurisdictions. My lord, coming
Yes.
back, my lord, I was on public order. And I was, my lord, on the judgment that the state cannot just say, my lord, that public order will be disturbed and therefore we will restrict your freedom. And I was inviting your lordship's attention to 1982 1 SCC page 71 where I stopped yesterday. Just have a look at that judgment, which is at, my lord, page 81 of compilation number 1. Compilation 2. Start compilation. And just one paragraph, my lord, at page 1. But somewhere in the 8 lines from the end of that paragraph, having elaborated the principles which should guide the exercise of that power, we hope and trust that in future power will be exercised by the executive magistracy in defense of established rights. My lord, Chief Justice got it, my lord?
Paragraph.
Paragraph 33, my lord. I'm sorry, para 33. Page 123, my lord. Running page 123.
123.
123, my lord. Having, my lords, about 8 lines from the bottom of para 33, having elaborated the principles which should guide the exercise of that power, We hope and trust that in future power will be exercised by the executive magistracy in defense of such established rights of the petitioner and the Shia community, and instead of prohibiting or suspending the exercise of such rights on concerned occasions on the facile ground of imminent danger to public peace and tranquility of the locality, the authorities would make a positive approach to the situation and follow the dictum of Turner Chief Justice that if they are satisfied that the exercise of the rights is likely to create a riot or breach of peace, it would be their duty to take from those whom disturbance is apprehended security to keep the peace. After all, customary rights by the petitioners
Mr. Kamath,
Protector of fundamental rights guaranteed under Article 25 and 26 of the Constitution to religious denomination who are desirous of so and so many. Then, my lord,
You were disconnected. We could not hear you. You
I'm
are
sorry.
on which
I'm
paragraph?
sorry. Lord, I
Which-
was on paragraph 33, my lord. I'm sorry.
Yes.
Not the last about 6 lines of that paragraph. Lord, you have marked it. What it only says, my lord, that the state cannot just take a facile ground of public order. It has to create a positive environment to facilitate exercise of fundamental rights. That's what it says, my lord. Lord, you may go through it. My lord, the next judgment which I want to cite, and this is the latest one, which is, my lord, of Justice Chandrachud, 2020, 12 SCC, page 436, which is at page 127, my lord, of this compilation. Just one paragraph, my lord. Para 50. Lordships may also note paragraph 46, 47. I will not read it, but make a note, my lord, para 46, 47, where, my lord, Justice Chandrachud, my lord, talks about the growing intolerance, about not accepting the rights of others. And in paragraph 50, he says, my lord, between placitum F and G, 156, paragraph 50, between F and G, in its capacity as a public authority, and this is what I commend for my lord's kind consideration, page 156, para 50, between placitum F and G, in its capacity as a public authority enforcing the rule of law, the state must ensure that conditions in which the freedoms flourish are maintained in the space reserved for free exercise of speech and expression. The state cannot look askance when organized interest, kindly see this, I'm sorry, the Chief Justice got it.
Yes.
156. 156.
Between placitum F and G.
Yes.
Paragraph 0. Between placitum F and G. In its capacity as a public authority enforcing the rule of law, the state must ensure that the conditions in which freedoms flourish are maintained in the space reserved for the free exercise of speech and expression. The state cannot look askance when organized interest threaten the existence of the freedom. State is duty bound to ensure prevalence of conditions in which of those freedoms can be exercised. The instruments of the state must be utilized to effectuate exercise of that freedom. When organized interest threaten properties of theater owners or viewing audience with it is the plain duty of the state to ensure speech is not silenced by the fear of the mob. Unless we read a positive obligation on the state to create and maintain conditions in which freedoms are guaranteed by the Constitution, there is a real danger that art and literature would become victims of intolerance. So, my lord, the state says if somebody wears a headscarf, there will be galata. Therefore, we are stopping everything. Can't be the reasoning. My lords, I will not trouble your lordships with more judgments. If your lordships can just have my written arguments, I'll just finish in 10 minutes, my lord. I have quoted everything. Just have a look at, my lord. My lords, the judgments which I cited, my lord, of Ghulam Abbas and Justice Chandrachud's judgment, my lord, in this indelibly 2020, according to me, my lord, give judicial recognition to the American doctrine of heckler's veto. Lordships may make a note of that. Heckler's veto is this, my lord, that I go on the street, I want to exercise my freedom. Somebody comes and doesn't like Devdutt Kamat's face and says, threatens me, how are you coming to the street? State says that, look here, yes, Devdutt Kamat cannot go on the street because somebody else is doesn't like, it may create trouble. So courts have taken the view, a heckler cannot be allowed to veto a fundamental right. And that's the heckler's veto doctrine. And according to me, my lords, Ghulam Abbas Ali and Justice Chandrachud have in India recognized that doctrine. And therefore they say that there has to be a positive obligation on the part of the state to create a situation for enforcement of fundamental freedoms. And those heckler's veto judgments, my lord, lordships will just make a note in my written note, page 14, my lords, para 30, 31 and 32. Three US Supreme Court judgments I have cited, which I will not repeat, my lord. Just make a note, para 30, my lord. Para 30 is one judgment, 31, 32, 15 to 16, my lord. 14, 15, 16. Then lordships kindly come to para 17, page 17, my lord. Lords, page 17, my lord, one of the arguments is, and that your lordships also, my lord, that order which your lordships passed on last Thursday, that nobody shall disclose any religious symbols. Lord, in our secular state, probably what your lordships had in mind, that nobody should display religious symbols. That's what the state says. But our secularism, my lord, is not, my lord, Turkey secularism. Our secularism is positive secularism, where, my lord, the state plays an enabler role for the exercise of fundamental rights, religious freedoms of all communities. We recognize all religions as true. And that is what, my lord, I have explained at page 17, para 36. Justice Shah's judgment, my lord, in Aruna Roy. Lordships have page 17, my lords, of my written note.
Yes.
Para 36. The Indian interpretation of secularism stems from the Vedic percept of Sarva Dharma Samabhava. In this regard, attention is invited to Aruna Roy, and kindly see, my lord, the quoted portion in para 8. I'm sorry, my lord. Yes.
Page 13
1-3.
in our
Page 1-3.
written submission. It is on page 13, para 36.
Yeah, I'm sorry, my lord. I'm sorry. Para 36, my lord. I think there is some page numbering problem. I'm so sorry, my learned friend. It's my mistake, my lord. Para 36, my lord. My lords, para 86 of Aruna Roy is quoted. And if your lordships have the highlighted portion, secularism, therefore, is susceptible to a positive meaning, that is developing understanding and respect towards different religions. The essence of secularism is non-discrimination of people by the state on the basis of religious differences. Secularism can be practiced by adopting a complete neutral approach or by a positive approach, by making one section of religious people to understand and respect the religion and faith of another person. Based on such mutual understanding and respect for each other's religious faith, mutual distrust and intolerance can be eliminated. Lords, what I am submitting is this. The state says that we are a secular state. We are not Turkey, my lords, where there is, my lord, negative secularism, where the state says that nobody shall display religious identity in public. That hijab ban was upheld, my lord, by that Turkish court, went to the European court, which was upheld. But their constitution is completely different. Our constitution is positive secularism, where, my lords, if we practice different faiths, that has to be recognized, that religious identities have to be recognized. Then, my lord, I have enumerated that I finished 25, my lord. I am saying that let's leave aside 25. Now, this is a innocuous practice of wearing a headscarf and not changing my uniform. And I say, my lord, this is a facet of the freedom of speech and expression. A reasonable restriction would be, my lord, that everybody wears a uniform, no difficulty. But a small exemption, if it is given of wearing a headscarf, Lord, I would say, my lord, that is in line with expressing that freedom. And that's what the Supreme Court said, my lord, that personal appearance, where I've cited that case in para 37, my lord, where I've said that freedom of appearance is part and parcel of Article 91A. And similarly, my lord, in paragraph 38, I have put it on the anvil of Article 21. I will not repeat, my lord. Puttaswamy judgment I have cited. And lastly, my lord, I have also put it on the ground of, my lord, Article 29. Because Muslims, my lord, will be protected under Article 29, being a religious minority, my lord, and at 29(2) as a cultural minority. And then, my lord, paragraph 44 onwards, what may really not arise for consideration in view of the others. Now, that was a situation before the learned single judge, where, my lord, these students were made to sit separately. And the question was, my lord, whether that violates Article 14. My lord, there I have said, my lord, that the segregation business, where putting Muslim students separately, wearing Hindu students separately, my lord, wearing hijab separately, that is completely destructive of our right to equality. That I have placed all those judgments also. And the last one, my lord, which I want to cite, last proposition, my lord, para 52. Mr. Hegde has argued this, my lord, that I say that under provisions of the Education Act, my lord, there is no power, lords, of the state to prescribe or to have this GO. And I have cited section 7, my lord. Section 7 is for prescription of syllabi, etc. My lords, the argument which I want to make on this Education Act is this. And please, my lord, this is a demurrer argument. The demurrer argument is this. Assuming you have the power to enforce a uniform, assuming that Muslim students, my lord, wearing a hijab cannot be given an exemption. Then I ask, my lord, where is the power to expel students from a school because they are not prescribing to that uniform? I can understand, my lords, people are wearing different uniforms, a disciplinary code. Wearing an extra, my lord, attire in the form of a hijab, and the school expels them. I submit, my lord, the doctrine of proportionality will come in. The lordship will have to examine this. This is not a case, my lord, where a student goes and fights with somebody and you expel him from a school or suspend him from a school. He is just asserting his religious rights under 25 and other fundamental rights. And you say that, look here, there is a uniform policy. There is an act which says that Rule 11 says that there is a uniform. And therefore, if you don't wear a uniform, I'll expel you. But expulsion has severe consequence in administrative law. Lordships are very well aware. I don't need to cite judgments. Doctrine of proportionality will come in. And therefore, my lords, I end.
In your case, the students have been expelled.
No, my lords, I am saying they're not allowed to come. It has the same effect.
Different.
Students not being permitted to attend class.
Not Mr. Kamath, but Honorable Chief Justice. Honorable Chief Justice.
They are not expelled.
Expulsion is one thing. Not permitting to gain entry to the institution is another.
Absolutely. Lords, my case is the second. My case is the second. That institution.
Doctrine of proportionality, when in case they have not been expelled, how you are applying the doctrine of proportionality?
I am grateful for that question. I'll
The
answer
passenger
that.
is not permitted. 1 second, Mr. Kamath. If
Yes,
a passenger is not permitted to gain entry to a train because he does not have a ticket, that's not a case of expulsion.
I bow
It's a
down.
condition.
Lords, it's my mistake. I used the wrong word. Lords, I'm sorry. I used the wrong word. They have not been permitted to come inside. And this is not a case, my lord. This is not a case, with greatest of respect, of my lord's passenger alighting a train. My lord, this is the case where a student, apart from other fundamental rights, my lords, 14, 19, 21, 25, 29, is wanting to access education, which is also a fundamental right under 21. And the state says, my lord, that we will not permit you inside the school. And in that context, my lord, I raise the doctrine of proportionality. Is the action of the state proportionate to what? That's the
It is
subject.
whether the
Therefore, my lord, to end,
he has not been allowed inside the class or inside the school.
inside the
Inside the
school, my lord.
classroom.
Yes, my lord. I am saying either which way, either inside the classroom or school, both have the same, my lord, legal consequences. Now, in that context, my lord, I end with this, my lord. Just have a look at your lordship's order, which your lordships passed, my lord. The detailed order which your lordships passed on Thursday. Probably, my lord, we were not in a position to assist your lordships that day because of paucity of time and certain observations here, my lord. I respectfully submit.
By that order, nothing was decided.
Nothing was decided. Whatever your lordship say, my lord, whatever
was also decided.
go down, my lords. Whatever your lordship says, my lord, as a constitutional court, my lord, has great significance, has great value, my lord, to citizens of this country. Now, kindly see paragraph 8. Firstly, we are pained by the ongoing agitations and closure of educational institutions since the past few days, especially when this court is seized of this matter, and important issues of constitutional significance and personal laws are seriously being debated. Absolutely correct, no? It hardly needs to be mentioned that ours is a country of plural cultures, religions, and languages. Being a secular state, it does not identify with any religion of its own. Every citizen has a right to profess and practice any faith of choice, is true. However, such a right, not being absolute, is susceptible to reasonable restrictions. Now, lords, this, in my respectful submission, is against the Constitution. Why I say this, my lord? Because Article 25, there is no concept of reasonable restriction, my lord. Article 25 is subject only to public order, morality, and health, my lords. Number one. Or, my lords, a law of social
Those are the restrictions.
Do you say that there are
I
restrictions?
am making a submission. Lordships may want to, my lords, have a different view. According to me, my lord, this
Yesterday
reasonable
we
restriction.
pointed out how the article starts.
Subject to.
Yes, Lord, I
Subject.
hold on. Yes.
Yes.
Yes. Then lastly, my lord, just have a look at the operative portion. Pending consideration of these petitions, we restrain all students, regardless of their religion or faith, from wearing saffron shawls, scarves, hijab, religious flags, or like within the classroom until further orders. I respectfully submit, my lord, the sweep of your lordship's order is, my lord, extremely broad. But I say that it is in the teeth of Article 25, my lords, and also other constitutional rights. And my lords, kindly make some leeway. Lordships are examining, my lord, issues of, my lords, grave constitutional significance of seminal importance. In the meanwhile, my lords, please permit us to, my lord, carry out this innocent faith, subject to whatever conditions your lordships may impose. We will have the same, my lords, uniform. We will, my lords, just wear an additional headscarf, because this consideration is going to take time, my lords. My learned friends, my lord, you lordships will have the benefit of erudite, my lord, submissions. The best counsels, my lord, are going to assist your lordships. So therefore, my lord, I respectfully submit this order, in fact, my lord, suspends fundamental rights. Please don't, my lords, continue this order from today, my lord, is my respectful submission. Lords, I bow down to your lordships for having heard me patiently, my lords. And I part, my lord, by also, my lord, mentioning that my friends, my lord, Nishan Patil, Nizam Pasha, my lord, and Shahul and Niyaz, have contributed immensely to the research, my lord, which has been placed before your lordships, and I am only the mouthpiece of their hard work, my lord. I'm grateful for a very patient hearing, my lord. Grateful, my lord.
It is submitted that respondent 5 institution has followed the Karnataka Education Act 1983, the Karnataka Education Institutions Classification, Regulation and Prescription of Curricula, etc. Rules 1995, referred to above, and directed the students, kindly mark this, directed the students to follow the uniform dress code in the college campus and classrooms. The long-standing practice of this uniform system is a settled fact, accepted and admitted by the College Development Committee under the chairmanship of local MLA, and other office bearers have discussed the subject on 31/1/2022. Kindly mark the date. I was prevented from entering the class or the school 3 days prior to 31st. On 28th, I was prevented from attending the classes. So they are banking upon a decision taken on 31/1 in the presence of some of the petitioners and their parents. The request of the petitioners was discussed at length. After analyzing the law, public order, and notions of secularism, kindly mark it, who are doing this? Notions of secularism, equality, and conflicting interest, it was decided that the existing uniform system shall continue. The students in petitioners cannot be allowed to wear hijab inside the premises of the institution, and if they violate the dress code and wear hijab, such act shall amount to violation of code of conduct of the institution and be considered as a subject matter of disciplinary action. Kindly mark this as a code of conduct of the institution. Kindly mark it. I'll show for a moment. There is no such code of conduct. It was made clear that strict action shall be taken against such indiscipline, and thus students were requested to follow the discipline and uniform dress code prescribed by the college. Copy of the resolution dated 25/1/2022, 31/1/2022, produced as Annexure R3 and R4 respectively. Para 13. It is submitted that the state government, in exercise of its power of superintendence and control over the institution under the Karnataka Education Act, issued directions on 25/1/2022 that the government is examining, kindly mark it, that the government is examining the larger issues of dress code and uniform system up to PU level, and there are conflicting views and interests in the subject, and in view of the sensitivity involved in the matter, a high-level committee is being formed to examine and report back with the recommendation to the government. In the meanwhile, it was also directed that respondent number 5 college shall continue with the existing uniform dress code till a comprehensive policy or decision is taken on the subject. The said direction of the government taken on 25/1/2022 and of the above proceedings of the College Development Committee on 31/1/2022 has been specifically communicated to the students through instructions dated 1/2/2022 by registered post. Copy of the directions are produced as R5 and R6. So kindly mark it. The government is yet to take a decision. It is constituting a high-level committee which is going to look into the matter, and only after that deliberation is over and a final decision is taken. As of now, government has not prescribed any uniform. Government has not prohibited wearing the hijab. Now kindly see para 19. Para 19 at page 29.
Para 19.
Para 19, 19, page 29.
Yes.
It is pertinent to that the government of Karnataka exercising its power under section 7(1)(I), 7(2)(g)(v), read with section 133 of the Karnataka Education Act 1983 and Rule 11 of the Karnataka Education Institutions Classification, Regulation and Prescription of Curricula, etc. Rules 1995 has issued Government Order dated 4/2/2022 regarding uniform policy for educational institutions in the state. Kindly mark, there is no prohibition for wearing the hijab here also. The said notification has been issued having regard to the conflicting views, demands by various educational institutions and students at large. After rising of the issue involved in these petitions, the students of various institutions of state of Karnataka have started insisting of clothes to be worn to their choice. They are seeking for relaxation and exemption from following uniform dress code prescribed by various institutions governed under the Act. In order to resolve the controversy, the government thought it appropriate to prescribe uniform dress code by virtue of the order dated 4/2/2022. Copy of the order dated 4/2/2022 is Annexure R8. Let us see whether there is any prohibition for wearing hijab in Annexure R8.
Page number?
Page number 116, the Kannada version. The English translation has been handed over to the court. I do not want to go into the controversy of Suvyavastha. It is definitely Avyavastha. Kindly come to the operative portion of the order. I will not trouble the court with the preamble to the order. So certain assumptions are made, certain opinions are formed. Sir, the order starts at page 116, 116. It is in Kannada. The English version has been handed over to the court. There appears to be a typographical error in the statement of objections. The order is dated 5/2,
Not 4.
not 4.
Whether it is 4-2 or 5-2.
5/2. Order says it is 5/2.
5-2 we have got. Just
Impugned government order.
That is the
Stated as
impugned government order.
4-2, yes, impugned order. Impugned government order.
Is it 4-2 and
So
5-2?
if there is no 4-2, there's a mistake in the statement of object. It is 5-2.
Mistakes are not only in words, figures also.
Please.
Yes.
Kindly come to the operative portion of the order. Yeah. Just before that, what they have somewhat may kindly be noted, as the Supreme Court and various high courts have held that restricting students from coming to school wearing headscarves or head covering is not in violation of Article 25 of the Constitution. And after carefully examining the rules under the Karnataka Education Act 1983 the government issues the following order. In exercise of the powers conferred under section 133(2) of the Karnataka Education Act 1983, we direct students of all government schools to wear the uniform fixed by the state. Students of private schools may wear uniforms prescribed by the management committees of the school. Kindly pause for a minute. Government itself has said they are yet to decide on the uniform. There is no uniform prescribed by the government. They are constituting a high power committee to go into that question. That issue is yet to be decided. In the meanwhile, they say school they should wear uniform fixed by the state. So as and when it is going to be fixed, it shall be taken note of. But as of now, this order is premature because no uniform has been prescribed. The students of private schools may wear uniforms prescribed by the managing committees of the school. In colleges that fall under the Karnataka Board of Pre-University Education, dress code prescribed by the College Development Committee, kindly mark it. Dress code prescribed by the College Development Committee or the Administrative Supervisory Committee must be followed. If the administration does not fix a dress code, clothes that do not threaten equality, unity, and public order must be worn. Kindly take note of the fact there is no ban of wearing hijab by any students, much less students of religious minorities belonging to Islamic community. It says the development committee will fix it. They will prescribe the dress code. Till then, clothes that do not threaten equality, unity, or public order must be worn. We are not violating equality. We are not violating unity. We are not violating any public order. Be that as it may, there is no order against hijab. That is the sum and substance of this thing. Now they have provided that the College Development Committee shall prescribe the uniform. May I request the court to take the Act, Karnataka Education Act. Sir, this is a complete code in itself. Entire aspect of education to the level of PU is covered by the Act.
You want to refer section 133?
No, I'll point out that this College Development Council is a non-existent body under this statute. It is an extra legal authority which is endowed with the power to prescribe the uniform, contrary to the scheme of the Act and the letter of the rules.
Yes.
May I request the court to kindly note down under section 2, the definition clause, all the authorities that are entitled to exercise power under the Act are specifically defined. Subsection 7 of section 2 may kindly be erased. Subsection 7 of section 2
Competent
defines
authority.
competent authority. It means any person, officer, or authority authorized by the state government by notification to perform the functions and discharge the duties of the competent authority under all or any of the provisions of this Act for such area or for such purposes or for such classes of institutions as may be specified in the notification. This is a competent authority, not endowed with any power to prescribe the uniform. And College Development Authority is not, Development Council is not. Then kindly come to the Managing Committee under subsection 19. Before that, Governing Council may be perused. Subsection 17.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.